Hello and welcome back to Learning Legislation with Cesar Lopez, Associate General Counsel of Texas Hospital Association. We are back for episode 2 here in the month of March 2021. And Cesar, I know you have a lot to talk about, so I'm just going to turn it over to you so you can tell our audience what has been happening on the floor of the state legislature for the last month.
All right, thanks, Susanna, and appreciate, again, everyone, the opportunity to be here with you guys. Hopefully last month's update was useful. I know we ran a little beyond our 15-minute intended time frame, but we'll try to do our best to keep this one short and to the point. As you mentioned, yes, there's a lot that has happened in the last month or so, obviously, both in and outside of the Capitol. But I just want to start off again by reminding you guys, I know we said this last month, but want to remind you guys again that our THA legislative app is out there. It is available. Again, if you guys have not had a chance to download or use this, it really is a useful tool to stay up to date with everything we're doing, everything that's happening at the Capitol. We push a lot of information out through this app. So again, if you haven't had a chance to download the app, I really suggest that you do. Keep in touch that way. And again, if there's anything that comes up that you can't either learn or resolve through the app, just feel free to reach out to any of us over here at THA, and we'll be happy to help you guys out. Okay, so the big one, a couple of big ones actually, but probably the biggest of the two is the governor ending his statewide mandates. This executive order GA34, was issued probably about 2 weeks ago now, as we record here today. It took effect on March the 10th, so we had about a week or so of sort of runway before that order took effect. Although I can tell you that we do know that a lot of folks were kind of operating as if the order had took effect almost immediately, even though that wasn't the case. So this order rather did a couple of things. It one, restricted the statewide mask mandate. Basically, there's no longer a Texas statewide mask mandate requirement for folks to mask. It also rescinded all capacity limitations, again, on the statewide level. So all the business and restaurant and et cetera capacity requirements gone as of midnight on March the 10th. Kind of buried within that executive order, and a lot of folks missed this, was the ability for businesses, individual businesses, to require masks of their customers, set capacity limitations, of course, as they like. So again, it was just the state saying we on the state level, on a statewide basis, are rescinding rather all of these statewide requirements. But businesses, if you want to keep those in place, please go ahead. A couple of things I want to note for you all. All our hospitals in the state of Texas have operated under emergency rules issued by the state for almost a year now. Those emergency rules were initially issued in April of 2020. They've been in effect in some form or fashion since then. They continue to be in effect despite the executive order GA34 and those statewide mandates being rescinded. I will tell you that we do expect those state emergency rules to expire on their own accord soon, probably at the end of the month, if not sooner. End of March, I should say, for those of you, if you're watching this a little later. We don't really know what that's going to look like. We do think that hospitals, regardless of an emergency rule, have the ability to require masking, have the ability to require screening at the entrance, as we've been doing for almost a year now. So again, we're kind of in a wait and see position with those visitation rules, those screening requirements. And as soon as we have something official from the state, we're going to kick that out to all the members again. Another reason for you guys to have that app handy in case we push that information out through that option, that avenue. We did draft an FAQ with regards to Executive Order GA34. If you guys want to go ahead and just go to our webpage, tha.org. It should be probably on the front page, but if not, you can just search for it. It should be pretty easy to find. Again, keep in mind that despite these rescissions, and again, I'm repeating myself here, but you guys do have the ability to require masking. You guys do have the ability to continue screening folks at your doorway. Do have the ability to limit capacity in places like your lobbies, your cafeterias, things of that nature. So if those issues do come up, again, if you need any clarification on that, just let us know. We're happy to walk through all of that for you all and with you all. The next issue, and again, we're kind of going out of chronological order here, but was the winter storm that hit Texas mid-February. Again, huge deal for everybody in the state. as you can imagine, it shifted the focus at the Capitol and on the statewide level, even if just temporarily. In the immediate aftermath of the winter storm, there were a ton of hearings, a ton of inquiries related to ERCOT and the grid and all that sort of stuff. And it kind of took the focus off of all the other issues that were already a little bit at play with the start of session. I think even more important than that, it essentially forced the state to lose a week. So like I mentioned last month, the regular session is a defined period of time. It runs from January to May. It's those 140 days, and that's that. So we lost a good 7-ish, maybe 10 days of time because of that winter storm. Those were days where there could have been bills filed, where hearings could have been held, things could have just been happening at the Capitol, and nothing happened during that time. And that doesn't sound like much, it's just a week, but again, in those 140 days of regular session, that's a big chunk of that time. So it knocked everything back a bit, a week or so, or maybe even more. We're still playing catch up with all of that and having to deal with all the continued fallout, the hearings on ERCOT and all those folks. It sort of turned an already unusual session even more unusual, and we're still kind of waiting to see what things are going to look like here in the next couple of weeks. Although I can tell you that in the last couple of weeks, we have had meetings at the Capitol. We have had hearings that we need to appear at and testify at and submit testimony for, and so things are starting to pick up. They're just not really picking up at the pace that we would normally expect, in a normal time, non-COVID year, but certainly picking up even, when you take COVID into consideration. So hopefully I'll have more information for you guys next month as to how, that schedule is moving along, whether or not we expect there to be a special session after regular sessions ends in May. But again, more to come on that. And so finally, just to kind of get to some of these bills of note, and some of these I've already referenced in last week's presentation. But again, just want to highlight a couple of buckets of areas that we've been dealing with and seeing a lot of activity on. One is, again, I think I mentioned this last month, liability. There's been a number of bills filed with regards to potential liability, not just for hospitals, but all businesses in the state of Texas with relation to COVID-19. So what these bills generally say, and again, there's several of them out there, is that if a business, which would include a hospital, acted in good faith with regards to COVID-19, read the CDC and the state guidelines and did their best effort to enact those requirements, whether it's, the social distancing requirements, the masking requirements, whatever it is. If a business acted in good faith in trying to comply with all that, and nevertheless someone very clearly contracted COVID while being at that business or partaking in those businesses' activities, there will be some liability protection against that business for any sort of lawsuit or injury or what have you that may have come out of that COVID-19 illness. None of these bills would cover the legal standard of willful and wanton or gross negligence, and that's basically a situation where somebody acts just with total disregard, where they do something obviously intentional with the intent to harm somebody, something of that nature. So if somebody went out and, I don't know what this would look like, but intentionally infected somebody with COVID, they knew that they were infected. They went and, let's say, coughed on that individual or somehow forced that individual to very clearly contract COVID as a result of that person's, again, willful and wanton, deliberate actions. That wouldn't be covered under these liability bills. But again, anything in good faith would be. I may have mentioned this last month, but there is a specific liability bill for healthcare. So it would specifically cover hospitals, healthcare providers, and the like. It basically says that, again, as long as all these facilities and providers did their best, acted in good faith to try to prevent the spread of COVID, and nevertheless that individual caught COVID, there's some liability protection there. They also go a little bit farther and say things like, if a hospital is unable to treat somebody as a result of the COVID surge, a hospital certainly at certain points during the last year, we're almost overwhelmed with patients. And so if somebody came in with even a non-COVID related injury, they were involved in an auto accident or having a heart attack or what have you, but everyone was busy dealing with the COVID surge, or vice versa. Somebody came to the hospital with COVID, the difficulty in breathing, but the hospital was busy dealing with a massive amount of trauma. Let's say there was a major auto accident or something related maybe to the winter storm. If there was an inability to really provide the normal level of care and treatment to those patients, again, in any way related to COVID, there would be liability protection for that as well. And so it's things like transfers, like inability to get an appointment with your primary care physician. It really kind of casts a pretty broad net with regards to these liability protections. So again, there's a lot out there. I don't want to spend the entire 15 minutes on this bill, but if you guys have any questions, just let us know. Again, happy to have that conversation offline. The next issue that we have been seeing a lot with, unfortunately, at the Capitol is end-of-life, EOL, as we kind of call it here at THA. This has to do with Chapter 166 of the Texas Health and Safety Code, which really is a mechanism for resolving a lot of these end-of-life disputes where you have the patient, or more often their surrogate, their family members, saying, we want you, the hospital, we want you, the provider, to provide all the care you possibly can for a loved one at their end of life, even though that continued care, those continued interventions are possibly and maybe probably when you consider medical probability, causing more pain and suffering to that patient than any benefit they may be receiving from them. So we've had these fights again for a number of sessions now. There is this bill that's been filed, and it has been filed currently, but it was also filed last session, that would require what we call treat to transfer, which is basically after a patient is medically and maybe even legally deceased, when that dispute resolution process determines that care is causing more harm than good to that patient, and there's any sort of dispute in that realm, this would require the hospital and the provider to continue that life-sustaining treatment, those life-sustaining interventions for that patient, basically indefinitely. Under the current dispute resolution process, there is a minimum of 10 days that care has to be provided before the hospital or provider can then withdraw care, again, after they determine it's not providing any medical benefit to that patient. But these bills will require that care to continue, again, indefinitely. And then you get into these questions about whether that patient is in fact deceased, whether you're keeping again, not to get too morbid, but a basically clinically, legally deceased person on life support. Questions of that nature start to arise. And so you're going to go down these moral slippery slopes that we really try to avoid. So again, just know that these bills are out there. We have concerns with them. We continue to monitor and work them. And again, any questions, just let us know. The next issue, again, I think I can do this pretty quickly, is dialysis. This is an issue that came up directly as a result of the winter storm, where these dialysis centers were effectively shut down because of the storm. They didn't have power, they didn't have water, whatever the case may be. Patients couldn't get there and receive their normal dialysis session. So a lot of these patients ended up presenting to the hospital and really the ER. And so there's some legislation being proposed and worked up that would address these issues, basically require those dialysis centers to maintain a generator, maintain enough supplies to withstand maybe a 24, 48 hour, 72 hour window where they don't have the normal utilities, or require them to notify the state before they sort of shut down for an extended period of time. But again, that's just an effort to keep some of these folks out of the ER, because we know that those patients are a major burden for hospitals when they do appear, because again, that's not their normal site of care. The next issue, maintenance and certification. This again is another recurring issue, and one that we at THA have dealt with for several sessions now. These are essentially a series of bills that would allow physicians, once they have their initial board certification, to maintain that title of being board certified, even though they don't really go through the maintenance and certification process that their specialty board requires them to do. So most doctors have to renew their board certification every 6 to 10 years or so, depending on the specialty. This would basically allow them to just get their initial certification and just be on kind of cruise control forevermore. So we certainly do have concerns with that. We want to make sure that all the physicians that work at our hospitals that claim board certification are in fact certified and maintain that certification and are showing that they're still competent in that area and meeting any sort of requirements that they may have to meet to keep that certification up to date. So again, recurring issue and one that we continue to deal with. The next issue is what we call, or what's been called, white bagging. It's a pharmacy-related issue, and it's basically a requirement for providers, pharmacists, to obtain drugs from an in-network pharmacy, even though that may not be the most convenient pharmacy for them to obtain those drugs from. So again, this is an issue that we didn't really know was an issue until this session, but certainly starting to engage on it. We're working with a number of our stakeholder partners on this issue. Hopefully I'll have more for you guys on this one next month, but again, just know that that's out there. The last two, I know we're running kind of short on time, but I'll go through these pretty quickly. Firearms, guns in hospitals, those are always major issues for us, as you can imagine. Certainly, I would imagine issues for y'all watching at home as well. Just know that we always, Texas being Texas, see a number of bills that would loosen up the requirements on firearms in hospitals, or rather allow the ability for more firearms to be brought into hospitals. And just know that I highlighted a couple of bills here. Generally, these bills aren't specific to hospitals. Sometimes they are, but oftentimes they're just basically, somebody with a concealed handgun license can carry a firearm into any business, period. It doesn't specifically reference hospitals, but it does ultimately affect us. So again, just know that these bills are out there. If you do have concerns in the space, let us know. We'd be happy to hear from you guys and have any thoughts that you guys have with regards to these types of bills. But again, they're constant. There are dozens of these bills that come up during every session. This session, of course, is no different. The last point, very quickly, just want to highlight to you guys that there are a couple of bills related to PHI and patient data that you guys should be aware of. Know that we, THA and AHA, our partners at the American Hospital Association, are fully engaged on these. And so if you want any more info on those, let us know. But basically, there is a new proposed HIPAA rule and this information blocking rule that you guys should know about, and would essentially combined shift the paradigm with regards to patient data, patient information sharing, in that, what we've known over the last years and years, and however long HIPAA and HITECH have been in place, the presumption is that patient data should not be shared. Under HIPAA, you protect patient data as much as you possibly can, unless there is an exception under the rule that allows you to share that patient data. Under these two rules, effectively, that paradigm is entirely shifted, turned on its head, and the presumption would be that information, that patient data, should be shared. There should be more interoperability. That patient should be able to be more portable with that information. Unless there is an exception in the rule that allows you to withhold it. So again, the current sort of presumption is you withhold data, you don't share data unless there's a reason for you to do that. The new paradigm, again, would essentially be the opposite. You are presumed that it is presumed that you should share that data unless there is a reason under the rules that you shouldn't. So again, a lot more to that, as you can imagine, a lot more complexity there. Let us know if you guys have any questions, but I'm happy to pass on any information that we can on any of this information. And with that, I think that wraps up this session. Suzanne, any questions or anything you think I need to provide more specificity on?
I think at this time, we've got a lot of information to process that's really helpful. It's also really hard to remember that just a month ago, we were going through this crazy winter storm, and really to remember how affected our hospitals and healthcare centers were during that time, and how compromised we all were. And now to really see how much legislation is being churned out because of it is also equally fascinating. So yeah. I just want to say thank you for your insights and expertise. And encourage everybody listening to reach out to Cesar directly or to anybody on the advocacy team to learn more about any of the bills that you heard about. Please keep an eye out on our website for our next month's update. We will push that out mid-April for you all. And I guess with that, Cesar, thank you for your time, and we can sign off here.
All right. Thanks so much.
All right. Bye-bye.